And welcome back. Today we're going to talk about the difference between a will and a trust because that's a question that's often asked of me. And it definitely is a question worth asking. There is a huge difference between what a will does and what a trust does. And sometimes one is after with the other, and sometimes it's not. So let's begin. A will is a list, a set of rules. You write it down and you basically ask a judge to validate that. And then the executor that you appoint through the will is going to gather all the assets of your estate that you have left behind and distribute it according to that list, that rule that you have put into your will. So when you write a will, that will goes to probate, period. So every time there is a will, there is probate. Now, I like to give the example of will as if I walk into a store and I try to buy a few things, and I know I'm only going to get a carton of milk and maybe a can of beans and a few vegetables, and I don't think that I'm going to need a shopping cart for it. So I'm going to pick up all those things in my two hands, whatever it is that I can carry in my two hands. I'm going to take it all and I'm going to start walking back to the check to the checkout. That is generally kind of like what a will would do. If you have as many things that you can put in your hands, you can take them, gather them, hold them, and walk out with them, right? Now, if you ever slip while you're walking out with all of those things gathered in your arms, those things are going to fall on the floor. And as they fall and scatter on the floor, you'll have to pick them up again if you're able to. Otherwise, you're just going to be slipped and fallen. And somebody else is going to come by and try to gather those things together and then give it to the person that you've bought those things for. I hope you understand what that example is and where it's going. Because with a will, you don't know where your assets are. Unless you, of course, have them really organized. But even at that point, your executor will still have to go to each one of those assets and get them and gather them and put them all in one place and then finally distribute them to your beneficiaries. That's what a will does. And for somebody who doesn't have much except for what they can carry in their two hands, where even if they fall, they do not drop those and it stays together and they can give that to the next person, that's great. That's what a will is for. A trust, on the other hand, is like a shopping cart. You've got a shopping cart going into the store, and you basically are putting everything from the shelf into this cart. You've made this box, this cart, as the trust. That's not really what a trust is. The trust legally is just an agreement between you, the person who creates that trust, the shopping cart, the person who owns it, and the person that is going to finally get it, that is the beneficiary, whatever's in the shopping cart. But more importantly, the person who is going to push that cart when you fall. So everything remains in that cart. That's your trustee. So the agreement is between you, the settler or grantor, the person who makes the trust, the trustee who is going to hold the assets of the trust for the beneficiary who's finally going to get what is in that trust. And with the shopping cart scenario, when you slip and fall, the shopping cart still slides and glides but stays there with everything in it. Nothing gets scattered. And the person that you've appointed as your successor trustee just goes on pushing that cart. The cart scenario or the example I give you is because the most commonly asked question I have is if I create a living trust, and this is a living revocable trust that we're talking about, what kind of freedom do I have with it? Can I put things in and out of it? Do I need to have another tax ID number? Do I need to have a bank account for it? What about my taxes? What about the income of the trust? Well, here's what it is. It's a shopping cart within a grocery store. And until you check out, there isn't anything that is stopping you from putting things in and out of that cart. Nobody stops you, right? You don't need a separate tax ID. You don't need a separate account. You don't need to have to ask anybody whether you want to take that can of beans and put it back on the shelf, take something else and put it back into the cart. Everything in that cart is yours until you, and it's free to take in and out until you're checked out. At that point, it is locked in. What's in the cart is in the cart for the person that you're giving it to. And that's what a trust does. The biggest advantage of a trust is that it avoids probate. But more than that, if you can bake in other things in it, like other sorts of protection, your trust can be a very precious gift that you give to the next generation. A huge gift of a way of passing generational wealth, a way of passing even the smallest amount of asset as a locked asset where your beneficiaries, creditors, people who sue them, any future divorces, bankruptcies, nothing can touch the asset. You're giving that asset protected for their life and possibly the life of their children if you want to keep, if you want to give that kind of protection. That's not necessary, but it definitely can be baked in. So that is an advantage besides the probate avoidance. That is that nobody needs to go to court to actually get your assets. One of the biggest advantages of a trust is also when you have out of state property, especially real property, because anywhere that you have a house outside the state of Texas, if you are a resident of Texas and we pass away here, well, there will be probate in those states outside for that real property. But you can always take that real estate and put it in a Texas trust. You can file the deed, record it where the property in another state actually belongs to a Texas trust, in which case that property can stay in the trust. You never need to do probate. The successor trustee holds that trust, and the beneficiary will finally get the benefit of that property within the trust. So there are many other advantages, of course, of a will and trust. When do you really just need a will? You'd need a will if you have no minor children and assets that you can pretty much feel and see and gather around, where you know for sure that if something happens, then nobody needs to grapple with trying to find them. And it's all right for your loved ones to go to probate because you have a simple enough estate where the probate will not make a difference. Your house is not going to be stuck in probate because maybe you don't own a house. You have accounts that are maybe jointly held, and you have contingent beneficiaries there. Or you don't have a lot of assets that need to be protected within a trust or distributed from a trust. That's when a will is an optimal situation for you. So that's the difference between a will and a trust. And I hope that helped clarify a lot of doubts. If you have any more, my website is notanilaw.com and my homepage has a book a call. Just click on it and I'm happy to talk with you. Have a great day.